Okay, we're on the record in People versus Clouse, case number 246718.
Third round.
Yeah, sir, if I can have you come right to the podium.
Oh, to the podium?
Yep.
Got you.
All right, the record should reflect Mr. Clouse is present here in the courtroom today. Mr. Brown, how do we want to proceed on this?
Your Honor, I have had conversations with Mr. Clouse. There has been an offer in the matter to plead to count one, larceny in the building, which is a 4-year, for dismissal of count 2, as well as the habitual notice. That would also be conditioned on restitution in the amount of $198.85 added for sentencing. I believe we are going to take advantage of that today.
All right, Mr. Rolla, is that a correct statement we offer?
It is, Your Honor.
Mr. Clouse, have you had a chance to talk to Mr. Brown about this plea agreement?
Yes, sir, I have.
Okay, is that how you want to proceed?
Yeah.
Raise your right hand, please.
Sure.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Clouse, are you currently on any kind of probation or parole?
No, not at the moment.
All right, and you understand that by pleading guilty to this charge, which is larceny in a building, that the maximum possible penalty you could face would be up to 4 years and or a $5,000 fine.
I do.
With that in mind, what is your plea to that charge?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, I do.
Okay. Also, you don't have an automatic right to appeal the plea that you're making here today.
Yeah.
If you wanted to try to appeal it or get it reversed.
No.
Yeah, but if you wanted to try to do that, I just need to make sure you understand that you would have to ask the next higher court up, which is the Court of Appeals, to hear your case.
Okay.
They could say no, and then that would be the end of any appeal.
Okay.
Do you understand that?
I do.
Okay. Has anyone threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we've said here in court?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty of this crime?
Yes.
All right. The information I have indicates that this occurred sometime in February or March of this year, 2024. Is that the correct time?
That would be correct.
All right. And at some point during that time frame, did you take some locking bottle caps from a family fair here in Gaylord?
Yes, there was one locked bottle cap on top of a bottle of vodka.
Okay. And did you take that from the store?
Yes.
Did you have any permission to remove that item from the store?
No.
And did you, was it your intent when you removed that item to put that to your own use?
Yeah.
Oh. Mr. Rolla, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Brown?
I am, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
We are not. We believe the courts also comply with courtroom statute as far as acceptance of things. Thank you.
Thank you. Mr. Brown, are you aware of any threats, promises, or inducements?
I am not aware, Your Honor, and I also believe the court has complied with statute court rule particular.
Thank you. Mr. Clouse, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of that charge. The court will accept your guilty plea. We will set this for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, it's important that you stay in touch with Mr. Brown, your attorney, so that you're prepared for that hearing.
Okay.
Before you leave today, you're going to meet with Mr. DeLeo from the probation department. He's going to set up a time for you to have a pre-sentence interview. Okay.
Okay.
All right. Thank you.
Perfect. Thank you.
People versus Garrison, case number 236650.
Mayor Brown, on behalf of Mr. Garrison, and for the record, Your Honor, he is currently lodged, or was lodged in Emmett County. He was supposed to be litigated.
That's what I'm checking out now, Judge. Thank you. I'll check one more section, but it appears, I don't see any notes that I found indicating you were where he was there. I'll double check Ritz in a moment, though, Judge, if you would.
Do you know, is he lodged in Emmett at the last hearing, Mr. Brown?
I believe he was. I'm checking on that as well.
We have an address on West Street for him.
That's what we had, Judge.
Your Honor, I am looking, the court signed a stipulation order to cancel bonds because he was lodged in Emmett County Jail back on April 20th.
Oh, yeah. Okay, so that clearly we don't, I don't see a red in the file.
I don't see a red, Judge.
Okay, are we gonna have a plea? I didn't receive a police report.
Your Honor, I was contemplating doing that. However, in speaking with Mr. Rolla as well as Mr. Garrison, it appears there was a plea offer in this matter. However, the plea offer was contingent upon, I'm sorry, I'm pulling it up, upon paying restitution in the amount of just shy of $46,000 either at or before sentencing, which is just not going to happen.
Okay, so Mr. Rolla, is this going to proceed to trial then?
I believe it is. As I understood, the people understood that the condition that actually couldn't be met, and although there would have been an agreement as to the amount of restitution, because I don't believe it was being disputed, it was also a requirement. And Mr. Garrison advised the prosecution where the money went, and then also be agreeable to testify against the what would then be a co-defendant, Mr. King, because we can't proceed against Mr. King without Mr. Garrison, and that was the condition that actually couldn't be met. So it looks like we're gonna have a trial.
Okay. All right, it was currently set for trial on June 27th. As indicated this morning, we do have a case, Mr. Brown, that has precedence over this case due to the age. So the trial dates would have had to be adjourned anyway because we have another trial taking place on those dates. So what the court will do is reschedule this for another 2-day trial at the court's next available date. And then the court will set this for a final hearing. Parties are able to negotiate some type of plea agreement and can enter into it at that time. Otherwise, we'll have trial dates set to go. Mr. Rolla, do you still anticipate this requiring 2 days?
I think so, Judge. And again, the prior to trial is the Duchesne matter, I assume. Very good.
Right.
Very good. Thank you.
And then I guess whenever we get those dates, council can writ Mr. Garrison, he's still lodged at that time.
And he's lodged in which county now?
Emmett County.
Emmett County.
Mr. Rolla, anything else that you need to address on this case?
Not these people. Thank you, Your Honor.
Mr. Brown?
Nothing further, Your Honor. Thank you.
And we're a little bit ahead. You know, Ms. Norman is here.
Your Honor, I do not resolution this year. I can put it on the record when the court calls the case. I have not had contact with her and, probably
All right, so our next hearing after that is at 2 o'clock with Miss Gan, so let's take a break until 2. And then we can start on Miss Norman's case and take care of Miss Gan. Okay, Ms. Brenner, are you able to hear me okay?
Yes, Judge, good afternoon.
Okay, good afternoon. Ms. Brenner, or- Okay, we're on the record in People versus Gan, or Gan. This is case number 236641. We have Ms. Brenner present today by video from, on behalf of the Attorney General's office. Mr. Brown is here. On behalf of Ms. Gan. Let's see, do we have Ms. Gan there at the jail?
Yes, sir.
Okay, great. Ms. Gan's present by Zoom video as well. Mr. Brown, can you tell me where things are at with this file today?
Your Honor, if I could just ask Ms. Brenner a question as to what the arrearages are currently.
They are now $11,895.65. She hasn't made any payments. I do see that she contacted the front of the court and advised them that she was working back in February, but no payments were ever made.
Okay, in light of that, Your Honor, there has been a plea offer made in this. However, it was a tiered offer. She would have to reduce her arrearages down to take advantage of any plea to at least $7,000, which would be almost $5,000 she would have to pay. In my conversation with Miss Gan just a couple of days ago, that is not going to be a possibility. I have reviewed with her possible defenses here. I've been very, very thorough with her, but it is my understanding at this time she is going to proceed to trial.
And
Okay.
today, counsel, if you wanted, she is charged with 2 counts. If she wanted to plead to count 1, I would dismiss count 2 today if she wanted to admit the violation in that manner.
And I have not had that conversation with her, Your Honor. If she doesn't feel comfortable in doing that today, I guess I would ask for an adjournment. I don't think this is set for a trial.
No, I don't believe we have trial dates set. Ms. Gan, have you had a chance to talk to Mr. Brown about not this most recent statement that the Attorney General has made, but about the prior matters?
No. But if I could say something, Your Honor, please.
Yes.
Back when my ex first got the kids, he got them back in
Ms.
October.
Ms. Gan, you don't want to
Yes.
get into the fact, you don't want to get into the facts of the case, okay?
Okay, I was just saying, okay, that was $5,000 that he received from taxes for the kids when he didn't have them that whole time.
Okay.
I'm now,
Those are matters that, Mr. Brown's telling you not to make too many statements because anything you say on the record here could be used against you later if you do want to go to trial on this matter. And,
okay,
if there are issues regarding the record keeping or, if you believe there were payments that were made that weren't properly applied or that there are amounts that they're saying you owe but you shouldn't owe because of the custody situation, those are all matters that would have to come out at trial. And that you should be talking to Mr. Brown, your attorney, about in confidential conversations, not here in open court, okay?
okay,
And that's for your own protection, because if you say things here that would be admissions, it could end up hurting you or being used against you later. So that's why I'm telling you that.
okay.
So I think what I'm going to do, Mr. Brown, I'm going to try and get this on for my next motion day in 2 weeks, so that you can talk to Miss Gan about this most recent offer by the state, and to make sure that we're really this is a case that's really going to end up on the trial calendar. Do you have any objection to that?
I do not. I think that would be prudent, Your Honor.
All right, Ms. Brenner, do you have any objection to that?
No, Your Honor.
Okay, so Miss Gan, that's how we're gonna proceed. I'm gonna give you an opportunity to speak to Mr. Brown here, and then we're gonna get this for hearing as quick as the court can, so that we can figure out how to go forward with your case, okay?
Okay.
Mr. Brown, anything further we need to address on this file today?
No, Your Honor, thank you.
Ms. Brenner?
No, Your Honor. So the court will just send us notice then when you can calendar it.
Correct, yeah.
Okay, thank you.
Okay, thank you. That's all for this hearing today. And then our next matter is People versus Norman, case number 246721. That was set for hearing at 1:45. It's now 2:10. Ms. Norman has not appeared for today. Mr. Brown on that.
Your Honor, this is a very new file. I just got this case back late April. Ms. Norman was incarcerated. I did speak with her at that time. The case was found over, looks like on April 25th. She was given a bond of $5,000, 10%. My guess is she did post that because she's not showing up on FineLink. I did call the number that she gave me that I have on file. It apparently was disconnected. Back on May 29th, I sent her a letter in the mail. It was never returned to me. So my assumption is that she received it. Other than that, I have not had any contact with her and I do not have any information.
Your role that the people take any position.
Judge, I think a benchmark is going to be appropriate in addition to the information provided by defense counsel. I'm also aware that she may also be facing methamphetamine charges out of Sheboygan County. She failed to appear there for a preliminary examination on April 2nd of this year. That was out of the 89th district court.
All right, so I'm not seeing any failure to appears in this court prior, so at this point, I think the court needs to set this for show cause. So the court will set it for show cause at the court's next available date. If Ms. Norman fails to appear for that date, then the court will request the prosecutor prepare next one. Our next hearing is set for 3 o'clock with Ms. Wilson, so we'll be in recess. Okay, we're on the record in People versus Wilson, case number 246717. Mr. Fragel, you have to find the podium, please. Mr. Fragel, tell me where things stand at this time.
The defendant intends to plead guilty to count one with the enhancement. Count two would be dismissed. The prosecuting attorney has no objection for entering a sobriety court agreement with Clare County, provided she meets the procedural and statutory requirements.
Okay. Has she applied there yet?
She has. She's actively enrolled in their program. Lisa Ashley has reached out. I think there's just some nuances in how the order should be written. And if we work that out, I think the prosecuting attorney as well would agree to the transfer.
Okay, Mr. Rowland.
That's correct, Your Honor, as long as the court has no objection to people.
Ms. Wilson, have you had a chance to talk to Mr. Fragel about this agreement today? Is that how you want to proceed as well?
Yes.
Can you raise your right hand? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Over your hand. Ms. Wilson, are you currently on any kind of probation or parole?
No.
And you understand that by pleading guilty to operating while intoxicated as a third offense, that the maximum possible penalty that you could face would be up to 5 years in prison and or $5,000 fine.
Yes.
With that maximum penalty in mind, what is your plea to that charge today? Do you need a? Second?
No.
No. All right. And then with that maximum penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify to trial yourself if you want it. Do you understand all those rights?
Yeah.
You understand that you're giving up and waiving all of those rights by pleading guilty today?
Yeah.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, which is the Court of Appeals, to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. Do you understand that?
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we've said here in court?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty?
Yes.
This happened on February 17th this year. Is that the correct date?
Yes.
And on that date, had you consumed some alcohol?
The night before, prior to the night before, early morning, yes.
Okay, the night of the 16th into the
Yes.
morning of the 17th.
Morning of the 17th, yes.
And then at some point then, after you consumed that alcohol, did you operate a vehicle on I-75 here in Otsego County?
Yes.
And did you have any blood or breath tests to determine the amount of alcohol in your system at the time?
Yes.
Remember what that was?
0.17.
Well, Judge, the parties, I believe, will
Oh,
stipulate that it's 0.190 grams per 100 milliliters.
Ms. Wilson, do you have any reason to doubt the accuracy of that test?
No.
Had you consumed enough alcohol that it affected your ability to safely and normally operate that vehicle? Had you previously been convicted of operating while intoxicated in 2019 in Genesee County?
Yes.
And then also in 2016, 167th District Court, is that also in Genesee?
Yes.
Okay. Mr. Rolla, are the people satisfied with factual basis?
As long as the court accepts the fact that I-75 is a public roadway, people are satisfied.
Mr. Regular, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people, we believe the court's complied with court and statute as to acceptance of pleas. Thank
Mr. Fragel, are you satisfied the court has complied with statute and code?
Yes, Your Honor.
Are you aware of any threats, promises, or inducements?
No, Your Honor.
Ms. Wilson, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Mr. Fragel, do you think we'll be able to wrap up the sobriety court technicalities in the next 30 days?
Maybe an extra week or two would help, Your Honor. There's about 6 signatures to gather
Okay.
in Clare County and Otsego.
Mr. Rolla, any objection to setting this out a little bit further
No, Your Honor.
for that purpose? You said she's already participating in the program.
Yeah, Clare County has accepted her. It's the procedure, you know, who's going to transfer, who's gonna sentence.
Yeah, no, I mean, I just asked because I want to make sure that we've got some
I'll take-
testing in place and that, you know.
Right, it's, no, they're ready for it if it can be worked out.
Oh. All right, then the court will set this for the sentencing hearing. Mid-July motion day. We'll try to fit it in at that time.
Thank
And then you're gonna meet Ms. Wilson with Mr. DeLeo here for probation before you leave the courtroom today. And then just make sure you stay in touch with Mr. Fragel and that you follow through with anything that the Clare County Sobriety Court's asking. Okay,
Okay, thank you.
that's all for today. Thank you.
Thank you.
Hearing set for 3:15, that's gonna be by Zoom, I believe. Oh, you are, okay, great. Mr. Brennan, all right. So we'll get started. We'll get kind of just keep.
I'm sorry, I'm sorry. Back, tap here, my bad.
Kind of periodically check and see if DOC.
Absolutely.
It should be delivered around 3:15.
Yes, sir.
We'll get started with the next case. Okay, Miss Medina, are you able to hear me okay?
Yes, Your Honor.
Okay, very good. Thank you. We're on the record now in People versus Kristen Medina, case number 226278. The record should reflect Ms. Medina's presence today by video from the Department of Corrections. If I could have counsel for your appearances.
Thank you, record Michael on behalf of the people.
And Maura Brennan, on behalf of Ms. Medina.
Okay, so we're on the record here today on a motion to correct an invalid sentence. I did receive your brief, Ms. Brennan. I had a chance to review that, as well as the legal basis for your motion and the attachments prior to the hearing today. Mr. Roll, I did not get a judge's copy. I'm not sure if you filed it.
I did, Judge, and actually this was Ms. Worker's case, but I told her I would make the argument today. In fact, we have, if necessary, I'll first do an offer of proof, and if necessary, then I'll Mr. Plea will actually testify as to what I'm about to advise the court, with the court's permission, of course.
Okay, is it something relating to the motion?
Yes, Judge,
Okay.
I did not receive a brief.
and there hasn't been one filed, Judge.
Okay. All right, do you want to wait until Ms.
And that's what we'll do.
Okay,
I just wanted to let the court know that we, if necessary, we have testimony that's pertinent to the motion.
okay, great, thank you. Ms. Brennan, anything you'd like to present by way of oral argument then?
Yes, Your Honor, just to begin with, I did not receive this from MDOC prior to filing my brief, but I do have a printout of Ms. Medina's trust account that I think might be helpful for the court and if it ends up on appeals, the court of appeals. And I have shared that with Mr. Rowland. He doesn't have any objection.
No, yeah, we have a copy, we have no objections, we're receiving it as an exhibit.
Get that. Thank you. Yeah, can you hand that to the court officer? Thank you. And do you want me to attach this as exhibit 8?
Yes, please.
Okay. Anything else by way of argument?
Yes. So I'll begin with kind of, first argument regarding, attorney's fees. And I know the court has read my brief. I'm not going to reiterate that. But I think I just want to point out that the key here is just that the Michigan Indigent Defense Act sort of tweaks MCL 769.1. And in that when someone is found to be fully indigent, the act and the commission actually has prohibited finding of attorney's fees against them. It really goes back to, the right to counsel. And so just, the particular things that I mentioned in my brief were, the proposed standards for determining indigency and I had, put the website on there and it's pretty clear. The appointing authority cannot require an indigent defendant to contribute to the cost of their defense. And I do think that there's a difference between the partially indigent defendant. They talk in the act about how then you have to go on and make a determination. But when they've been found to be fully indigent, which by exhibit 5 attached to my brief, Ms. Medina has, I believe that the MIDC Act prohibits, any, and I realize that, $350 is not a lot of money to you and I, but I think when you're incarcerated and you look at, the scheme where anything over $50 that is deposited in the trust account, 50% of that is taken, $350 becomes more important there and more, more of a burden. So that's all I'd like to add to my brief. If the court has any questions.
I do have one question. So, and I understand the point with regard to, the trust account and what the Department of Corrections takes out. And I get that applies to kind of the enforcement, because I view the cost as there's the court's ability to impose or assess costs for things like attorney fees, and then the court's ability to collect or enforce on that, right? I mean, there's a whole ability to a pay analysis that has to go when the court is going to incarcerate somebody for failing to pay, for example. So I get your argument when it comes to Medina's ability to pay while she's incarcerated, but that doesn't really go to the court's ability to assess the amount, right? I mean, that's a different argument.
I mean, I think that with respect to this first argument on the attorney's fees, I think that we're talking about the ability to assess that. I mean, and if you look at the MIDC Act, you know, it distinguishes between fully indigent defendants and partially indigent defendants. And you know, there's been, as I said, at least one in the cases unpublished, but basically, you know, the Court of Appeals saying, look, if you read these two in par materia, then you have to say that, you know, when somebody's fully indigent, when an indigent criminal defense system determines a litigant is totally indigent, neither the system nor the trial court ought to include an assessment of attorney's fees, and that was in People versus Sedgman. So I think in the next argument, you're right, Your Honor, the distinction is between you know, the enforcement versus assessment.
So that really, I mean, your argument is that case and the MIDC Act basically supersedes, or really in cases of fully indigent people. Bring my reading glasses.
Right, in cases
780
769.1.
or 769.1A or K rather, is completely like meaningless when somebody's fully indigent. In other words, there should be something in there. Legislature should amend that portion of the statute to say somebody's fully indigent, the court cannot collect.
Or just reading the two acts in par materia, because the Indigent Defense Act is more specific and it was enacted after, you know, the prior statute. So really by statutory construction, I think it does change the interpretation of that act.
Okay. Yeah. Okay, thank you.
Did you want to take these one at a time and then?
No,
Okay,
go ahead.
all right. And so, you know, really in terms of the second argument, you know, because Ms. Medina has now, you know, asked the court to determine, you know, has said that based on her indigency, she doesn't have the ability to pay the rest of the costs. And again, $850, which includes the attorney's fees. Without it, it would be like 500 and something. Isn't a lot to you or I. But again, when you look at this scheme that happens with 769.1L, where anything that's deposited more than $50, they automatically take 50% of it. It really does make that amount of money more important in terms of what she can, you know, can do. And so I just asked the court to look right now, and I think that People versus Jackson said, you know, absolutely you can impose those fees, but you know, when you go to enforcement, that's when the court has to take a look and say, does this person have the ability to pay? And Miss Medina is incarcerated. She, you know, pointed out in one of the exhibits that she had actually previously filed before I was appointed that, you know, her job is she makes about $15 a month. She doesn't have any savings. She doesn't have any, you know, any money other than that. The only things that's being deposited in her account are really gifts from her mother. And so she's not asking that those other fees be waived. She's just asking that they be suspended until such time that she does have the ability to pay. And I just want to point out too that in People versus Jackson, the court says, you know, that the question becomes, does the person have the ability to pay, or whether it would impose a manifest hardship? And I think those are two different things. I think the first question is, does the person have the ability to pay? And I think the second one is sort of a less, you know, rigorous standard. Like, I think that you don't even need to go to manifest injustice because she just doesn't have the ability to pay, period.
Wouldn't that really apply to everybody who's incarcerated though? Department of Corrections?
Well, not necessarily. I mean, if you have, you know, money in a bank account that somebody on the outside is depositing money for you.
But if they do that, the department still takes 50%, right?
It does, but
So
I think
nobody's
that's,
gonna do that.
well, but I think that's a different question, whether someone has the ability to pay.
No, but wouldn't I really have to look at whether or not her friends and family have the ability to pay? Because everybody can give me an accounting, right, from their prison account saying that they don't have any money because their friends or relatives don't want to put money in there because they know that half of it's going to get taken out, right? So everybody who's in Department of Corrections is really going to be indigent if they want to be. It's really not an indication if they're actually indigent.
I actually would, if Miss Medina had bank accounts on the outside, you know, I don't think she would be indigent. And so I would think, I think that's a distinction. But I think also the case that I cited, People versus Strange, the United States Supreme Court, which actually People versus Jackson mentions. I think that's really interesting in terms of this question, because it basically says that, if you are imposing and enforcing costs, this was the, in People versus Strange, it was a Kansas court scheme in terms of recoupment of costs that the court was looking at. And in that case, what happened is they didn't give the same exemptions to people that are incarcerated versus if somebody wasn't incarcerated, what exemptions would be given to them if they were unable to pay in terms of, lien and can you take their house, or, and it was different in terms of incarcerated, this recoupment scheme or civil fines if you were on the outside. And the court said, if you make a difference between people that are incarcerated and in terms of the way that you impose fines on them or costs and people are not incarcerated, it violates equal protection. So, I really think that if you're looking at Ms. Medina's ability to pay, it has to be looked at in terms of just her ability to pay. I think if someone is, in any other scheme where you're looking, is this person indigent, say she wasn't incarcerated, and the court is looking at her and saying, well, she's got this amount of income, she's got $14 a month, they're not going to be taking anything, even if we know maybe that her mother gives her money sometimes, the court's not going to be taking her money because she's indigent. I mean, I think the court would find she doesn't have any ability to pay. And so I think that you have to, assess it in the same way for someone who's incarcerated, if you want to stay without violating equal protection.
All right, thank you.
Thank you, Your Honor. The case is cited by defense counsel Strange, which is a U.S. Supreme Court case, 1972 case, 407, 128 and 135, and then People versus Jackson, I believe that's a 2009 case, if memory serves me correctly, 483, 271, a Michigan Supreme Court case. Those are, quite frankly, cases that don't apply in this matter. Our courts, in fact, our Michigan Supreme Court has more recently looked at the issues of the implications of MCL 769, 1K subsections 1B3, where they found it constitutional, because that was a challenge, that the argument that was just made, that it was somehow unconstitutional. And then, of course, in People versus Edwards, that was also dealt with the same thing, that dealt more specifically, however, with court costs and the court's ability to order costs and attorney fees under MCL 769 1K B3. Both of those were decided in July of 2023 this year. The first case is Supreme Court case number 163-073. The second is 163-942. The court has actually, first part, distinguished the argument that the defense is trying to make, because although a claim can be made for indigency, as our Michigan Supreme Court said, is since the Department of Corrections only takes an amount over $50, the person is not indigent. Second, it's a situation where they've also determined that the court has the authority to impose fines and costs. And when you're looking at collection, which is, as the courts narrow the issue, that's really at the point you're looking at whether or not they have the ability to pay. Otherwise, the argument could be made by every prisoner, oh, I'm sorry, I don't want to pay this. I'm not going to put any money in my prisoner account because money that I owe to victims or the state or whoever it might be, I don't want to pay them, so I'm going to claim indigency where it effectively makes the statute moot. That's just not an accurate argument, Judge, because the courts have found that they're not indigent, and B, it also doesn't go to the court's ability to order it in the first place, which is basically the argument they're also trying to make. And more importantly, C, it doesn't come into play until you go to enforceability. So for all of those reasons, quite frankly, and we've already had this issue decided several times. I don't know if you've decided, I know Judge Hunter has at least once or twice on this very fact. The point is that A, they're not indigent, and B, it goes to the argument where you have to go through that whole procedure to determine whether or not they're indigent, only when you try to enforce it.
Okay, thank you, Ms. Brennan. Any response?
Yeah, I just would like to say, I'm not familiar with the cases that Mr. Rowland is citing because I didn't receive a brief from him, and so I haven't had the opportunity to look at those and, opportunity to possibly refute them. So I would just ask that if the court is going to consider those arguments, I hate to say this, but that, we adjourn until a time is which I can take a look at those arguments and consider them and respond to them. Other than that, I would just say that in terms of enforceability, it is being enforced because as the trust account shows, there is money that is being withdrawn from Ms. Medina's trust account to meet these court costs. I think it is being enforced.
Okay. All right, thank you. Again, I did have a chance to review the brief filed by the defendant, as well as the law that was cited, and taking into account written submissions as well as the arguments of the parties here on the record today. I think it comes down to a couple things. Number one, again, what is the court's authority to impose attorney fees? The court has statutory authority pursuant to MCL 769.1K4 to order defendants to reimburse for attorney fees as part of a sentence. And I get the argument that 780.991(3)F modifies that in some way because of the language in there about MIDC's statutory requirement to establish standards for when somebody's partially indigent as to the collection of fees in that circumstance. And I read the case that you cited, Ms. Brennan. At this point, I don't find that it supersedes or invalidates 769.1K4. Number one, it was an unpublished opinion, the one that cited. I think if the court was going to completely eliminate a trial court's ability to impose reimbursement for attorney fees on a fully indigent defendant, I mean, that's a pretty significant decision. I don't think it would be an unpublished decision. And so that's why I just don't think that unpublished decision stands for that proposition that the court now can only impose reimbursement in situations where a person is determined to be partially indigent. So again, I think 769.1K still allows the court to impose that. I think the court has to find, based on the cases that I read, that number one, the fines are supported by some type, or the reimbursement is supported by some type of factual basis, and that the defendant hasn't already been required to reimburse under the MIDC Act in some amount. So the court looks at the amount of attorney's fees ordered in this case, the type of charges that Miss Medina faced, number of proceedings that court-appointed counsel assisted her in, the length of the time that, although she was represented by private counsel for a period of time in this case before she was appointed counsel. I think that the reimbursement amount charged by the court is more than reasonable based on the circumstances, the individual circumstances of her case, the complexity of the charges against her, the number of hearings that the court held in this case. So the court finds as a factual matter that the attorney fee that the court ordered to be reimbursed was justified in this case. The other component is whether or not the court can order collection of that. And in my view, I don't view it as a two-part analysis. Number one, ability to pay, and then manifest hardship analysis. In my view, the ability to pay analysis comes in when the court is going to impose some type of sanction, in particular imprisonment or incarceration, for a failure to pay, and that's not what's happening in this case. Ms. Medina is incarcerated, and as a result of her sentence, not because she hasn't or isn't able to pay the fines and costs that were imposed. So I don't think the ability to pay analysis comes in that reason, number one. Number two, again, I think any inmate in the Department of Corrections can make themselves indigent by choice. And so therefore, it's hard for the court to determine which inmates are truly indigent, which ones are indigent by choice because they're not having money put into their account, or they're choosing for whatever reason not to have income, so that they can avoid having to pay half of whatever they bring in, or over $50, whatever it is, into fines and costs. So again, I think that inability to pay analysis isn't appropriate in this case because of inmates' ability to make themselves indigent while they're incarcerated. As it relates to a manifest hardship, I reviewed Miss Medina's original brief. I reviewed the brief that was submitted in support of this motion. Miss Medina hasn't provided any factual basis to the court so far to indicate that her situation is any different than any other inmate in the Department of Corrections, or that she's suffering some type of hardship that's different or greater than any other inmate who is put in the position that she's put in, where she's earning a little bit of income, has to find ways to pay for personal items and so forth, along with paying fines and costs. So the court finds that there is not an undue hardship in this case either. So for all those reasons, the court is going to deny the motion. Ms. Brennan, I would just ask that you prepare an order and either submit that with a stipulation as the form or a set of people.
Okay, thank you, Your Honor.
Thank you.
And for benefit of that counsel, she just wants to prepare the order, forward it to my office by email. I can give her permission to sign it, and then it can be immediately filed with the court, save her having to do a 7 days.
Okay, thank you. I can prepare a stip in order and then email that to you.
Just a proposed order is all you have to do.
Right, thank you. That concludes this hearing, and we're going to go ahead and disconnect from Department of Corrections, and then we have one more day here, and those parties are connected. Mr. Baker, are you able to hear me okay?
Yes, sir.
Okay, your attorney's connecting in, and then we'll get started with your case.
Okay.
Ms. Siegel, are you able to hear me okay?
Yes, Your Honor.
Record, this is People versus Lawrence Baker, case number 216087. The record should reflect Mr. Baker's present today by video from Department of Corrections. We have his attorney, Ms. Siegel, present by video as well. Mr. Roll is present here in the courtroom. This is a motion to correct an invalid sentence, and Ms. Siegel, I did have a chance to review your motion and the brief supporting that. For the record, I also had a chance to review the transcript of the sentencing hearing in this case. Mr. Rolla, on this one, I did not see a judge's copy.
No, Judge, we didn't even get the request for the motion until after it already been too late for you to even file the response brief. If the court allows me some oral argument, I will make that. Thank you.
Okay, Ms. Siegel, anything that you wanted to present today by way of oral argument in support of your motion?
I think between the motion and the brief, it's pretty much summed up in there. I noticed one missing element to her motion and brief was that Mr. Baker didn't object at sentencing. And I would just want to, by way of explanation, just inform the court that he said that, I think he would say that, his lawyer obviously didn't go over it carefully with him. There's the glaring error of it saying no handicaps on the first page when in the body of the PSI, there are handicaps. So that's a simple thing that could have or should have been caught. And I also wanted to point out, Mr. Baker does suffer from, he had a head injury, and that was the main point of this. The date that the court was led to believe the head injury was 2019. It was actually in 2022. And I think that that's a big difference. I think that if the court had known that he was more acutely suffering from this head injury, it may have looked at it differently. And I would also like to point out that that could be another possible reason why he didn't object to the error in there. And Mr. Baker is hopeful if the court knew that his head injury was more recent, his medical needs were more acute, and that he may have gotten a local jail sentence or possibly probation. I know there is a mandatory minimum on this OWI third, but that he would have gotten something where he could have taken care of his medical needs and stayed local in the community. So that's all I have, Your Honor. Mr. Baker, if you were sitting next to me at the table, I could ask you if you had any questions for me. I don't necessarily want you to talk on the record without my advice, but could you tell me, have I missed anything?
You brought up that I had the head injury and oh, I don't know, you don't want me to talk, so I don't know what I should say, because can I say anything about my lawyer's condition at the time that I was?
No, I was just wondering, did I?
You're breaking up, I can't.
Oh, go ahead.
You was breaking up, I couldn't understand you.
Oh. Okay. I just wondered if I missed anything. It was just you wanted the court to be aware of when your medical injury was, and you wanted your PSI changed to say that you have a physical handicap, correct?
Yeah, yes. Okay. Good.
Okay. All right. Nothing further, Your Honor. Thank you.
Thank you, Mr. Rolla.
Judge, I was present at the sentencing, as you were as well. This very argument was made at the time of sentencing. And again, as I recall, Mr. Plea, I believe was Mr. Plea indicated, the information provided in the PSI was provided to him by the defendant. And even if, in fact, for argument's sake, let's take the position that the defendant is correct, that this argument, that this information in the PSI isn't accurate. I would also indicate to the court, it's also not material to what this court did for sentencing. Now, if the court wants to have the PSI corrected to reflect that, that's fine, but it's not a material difference and it wouldn't change what the court did for sentencing.
Thank you. Ms. Siegel, it's your motion. Anything in response?
No, Your Honor.
Okay. So again, I think Ms. Siegel's accurately stated the law here in terms of the grounds for correcting a sentence. And the defendant is entitled to have an accurate PSI and is entitled to have the court consider accurate information prior to passing sentence. In this case, frankly, I don't remember if the PSI had the wrong date in it or not, but what I do know in reviewing the transcript is, and I'm referring specifically to page 9 of the sentencing transcript, and that was the hearing that was held on August 21st, 2023. On page 9 of lines 13 through 17, during Mr. Baker's allocution, he did inform me directly that the injury had occurred the preceding February, not in 2019. So Mr. Baker did give me correct information during his allocution at sentencing. So at the time that I passed sentence on this case, I did have the accurate information. Even if it wasn't accurate at the PSI, I got the accurate information from Mr. Baker during the sentencing hearing. So at the time that I passed sentence, I was doing so with knowledge of the correct timing of that head injury that he sustained working at Shanty Creek, I think. And so he was sentenced with correct information within the knowledge of the court. Also, I would say that in reviewing that transcript and recalling that case, it's clear to me that the pertinent factors to the court's sentence was Mr. Baker's prior history of drinking and driving offenses and the fact that this was his third offense, drunk driving. And the court's concerns that he continued to reoffend despite lesser penalties previously. And so in the court's opinion, prison sentence was warranted in that case in spite of his physical difficulties, regardless of that. So for those reasons, the court finds that the sentence should not be or does not need to be corrected. However, I agree to the extent that the date of the injury is referenced incorrectly in the PSI, I do think that should be retroactively corrected so that anybody else looking at that PSI going forward has the correct information if they haven't reviewed the transcript of the sentencing hearing. So, Ms. Siegel, if you'll prepare an order that reflects that the court's denying the motion, however, the court is going to order that the PSI, to the extent that it has the incorrect date, that it be corrected to reflect the correct timing of the injury.
Okay.
Would have been,
Your Honor, I do usually, I do usually forward proposed orders granting and denying, and I do have in my file that I sent those. Do you have a copy of those in the record or in the file?
It wasn't attached to my judge's copy, but let me look in the file. It may have been attached to the file copy. Oh yeah, it was. Okay. Okay, yeah, we do have an order. Mr. Rolla, did you want to review this before?
I've seen it, Judge. I have no objection.
Okay. All right, so Ms. Siegel, I'm just going to hand right in there the portion about correcting the PSI. Otherwise, I'll sign your order as presented. Okay.
Thank you, Your Honor.
Okay, Mr. Rolla, anything further today?
No, Your Honor, thank you.
Ms. Siegel, anything else that we need to address for the record today?
No, thank you.
Okay, thank you. That concludes this hearing. All parties on this case are free to disconnect at this time. And that also concludes the court's afternoon docket. The court will be in recess until 9 a.m. tomorrow.
Judge, as a housekeeping matter, my docket indicated a 3:45 hearing. Is that been removed? On Davis?
Yeah, I don't have that on my docket. Yeah, that must have been removed at some point.
Right.
Since,
Okay, I didn't see it on the one that was just printed today, but according to all of the notices that our office had, they still had it on the docket, so I forgot to ask. All right, thank you.